Good afternoon, everyone, and welcome to the 2021 AILA Annual Virtual Conference. We are pleased to present this session titled U.S. Immigration and Customs Enforcement, ICE Open Forum. My name is JJ Area, one of AILA's education program managers, and it is my pleasure to be your session moderator. I would like to formally welcome the participants who are joining us today. Please note that today's session is being recorded and it will be available as an on-demand recording on the virtual site within 24 hours. To submit questions, go back to the virtual site window where you entered the session and then click on the discussion chat button located below the session description. All conference handouts and materials are available in your AILA Agora digital library. If you will be seeking CLE credit for your participation, a 4-digit attendance verification code will be provided at the conclusion of the session. Please see the CLE info tab of the virtual site for instructions on how to enter your credits on WebCLE. Please note CLE credits not reported on WebCLE by the published deadline will be subject to an administrative late fee. If you would like to turn off the subtitles, press the live transcript button located on the bottom right of your screen and select Hide Subtitle, which will disable the live transcript. At this time, I'd like to turn the session over to discussion leader, Sui Chung, AILA EOIR ICE Joint Liaison Committee Chair from Miami, Florida, to introduce today's speakers. Please go ahead, Sui.
Thank you so much, JJ. Good afternoon, everyone. Thank you so much for joining us. We're very excited to be here. Very excited that ICE is here with us today as well. We have a lot of information to share. I will introduce our panelists today. We have Aaron Hall, partner at Joseph & Hall PC in Aurora, Colorado. Many of you know him. He's currently our vice chair of the EOIR ICE Liaison Committee, and he also serves on AILA National's Amicus Committee. We also have John Tresvenia, Principal Legal Advisor of U.S. Immigration and Customs Enforcement. We saw Mr. Tresvenia this spring at our conference. We're thrilled that he's back to talk to us about the PD memo. He, as all of you know, he has extensive experience in immigration law and policy matters. He has a very distinguished career in government service, has had many significant roles, served as Judiciary Committee General Counsel, and he was former Dean of University of San Francisco School of Law and was previously President and General Counsel of MALDEF. I'd like to introduce Michael Bernacki, Chief of Staff for Enforcement and Removal Operations. His career began in 2004 as a USCIS clerk in Phoenix. He served as a Border Patrol agent thereafter and was detailed at Yuma Public Affairs Office. In 2009, he was transferred to Detention and Removal Operations. Prior to his current position, Mr. Bernacki served as Deputy Assistant Director of the Criminal Alien Division and was previously Unit Chief for Removal and International Operations, where he led diplomatic efforts, case management, and removals to various countries. He is the recipient of 4 ICE Director Awards and ICE Principal Legal Advisors Award. Mr. Todd Thurlow, Acting Assistant Director, Office of Partnership and Engagement for ICE is here today. He has been in immigration law enforcement. He has been in immigration law enforcement for over 2 decades. He is currently Assistant Field Office Director for ICE Enforcement and Removal Operations for the New England region. For the past 13 years, he's worked closely with AILA attorneys. Many of you probably know him from Boston. Welcome. Thank you so much, all of you, for joining us. We really, really appreciate your time and efforts today. Mr. Tresvenia is going to start with opening remarks and we will move into our questions. Principal Legal Advisor.
Thank you, Sue, and good afternoon, everyone. I'm very pleased to be with you. And while under the law, I'm the Principal Legal Advisor to the ICE Director, I have a greater responsibility as a public servant. And that's the spirit with which I want all OPLA attorneys, and we do as career civil servants take that responsibility. The PD memo is infused with that point of view. Similarly, AILA members, very dedicated, vigorous advocates for your client, but also have a larger responsibility to immigration law and to the system of justice. So we are very much linked, and I very much valued the opportunity to work with AILA, certainly SUI and others, to be able to make sure that the general public, clients, members of our communities understand the approach that will be taken by our OPLA attorneys in the proceedings. So today is a great opportunity to be able to do that. Also, just want to mention and congratulate your new board members. I think demonstrating your spirit in public service, your 32 pro bono champions that you just recognized. Olivia Lee, a new director for AILA, someone who I've known for a long time. We're both from San Francisco, both have a common mentor, Dale Manami, her boss, my mentor starting when I was starting in law school. So we have a lot in common in terms of being able to achieve justice. And that is the spirit with which Secretary Mayorkas and ICE and our OPLA attorneys will be carrying out our prosecutorial discretion memo. And I look forward to talking with you today, and certainly in the near future, you're going to hear from Todd later, the importance of extending this discussion, not just for today, but for throughout, and particularly at the local level with our local chief counsel.
Thank you so much, Mr. Tresmania. Mr. Bernanke, would you like to make some remarks, please?
Sure thing. Thank you so much for having me here today. I very much cherish and value the time that you have allotted for me. I know that there's a lot of substance and a lot of topics that you all want to cover, so I don't want to belabor introductions on my end and maybe get to the topics at hand. I do want to note, however, that AILA is very much, and a lot of the stakeholder groups that we do deal with are very much where the rubber hits the road, so to speak. We hear from our staff quite a bit, on the Euro end of things, but it's always good to get the stakeholder perspective. That way we can implement some suggestions and get some feedback in terms of how our operations affect stakeholders and affect the population and the individuals that we impact through our work on a daily basis. So again, thank you so much for having me, and look forward to your questions.
Thank you. Mr. Thurlow, welcome.
Thank you, Sui. I just wanted to also thank the members of AILA for having me on your panel today. It's a pleasure for me to speak to the national AILA audience after having so much interaction with our New England-based AILA attorneys. I spent many years working as a liaison to the New England AILA attorneys, and I've enjoyed it very much. It's been a very beneficial relationship for us both. As acting interim assistant director for the Office of Partnership and Engagement, I'm going to be overseeing what we refer to as our community relations officers throughout the nation. These CROs will be working in concert with the various chief counsels throughout the nation to bring information about this recently released prosecutorial discretion policy to members of the community. So that is basically why I'm here today, to sort of facilitate that and encourage you all over the country to reach out to your contacts, whether they be at the Office of Chief Counsel or with our community resource officers to get this information about PD out there. Thank you.
Thank you. I would like to mention that Mike Davis, Executive Deputy Principal Legal Advisor, is also here to answer questions. You may see him appear and also speak. We've seen him many times. He's a frequent visitor, guest at our conferences. Thank you so much, Mr. Davis, for joining us. Lastly, I just want to say, I want to thank our committee, our Vice Chair, Sarah Owings, our senior leaders, Amanda Kevaney and Andrew Nietzscher, for all of your work, as well as AILA staff, Kate Voigt, Jennifer Whitlock, and Greg Chen. It was a tremendous amount of work to get where we are, and we really appreciate all of your efforts. Thank you so much to the National Committee and all of our local liaisons who have contributed to today's agenda. And thank you, JJ and Lizzie, for your efforts. So we're going to move right into questions. I ICE has to leave right on the hour. So we will move into our questions on the PD memo. So the PD memo does talk about the established email addresses. Mr. Tresvenia, will those be posted, made available to the public?
Yes, our PD is intended to be very locally driven, respondent driven. So the way to do it is through our local email boxes. They are now on our website, our ice.gov website on the OPLA page. So that's how people can start to make their requests to the local chief counsel.
Thank you. And the memo seems to anticipate that requests are affirmatively driven by respondents counsel. How will OPLA ensure that those who are unrepresented have access to PD and the ability to make requests?
Well, we're going to be doing a lot of outreach. This is one example at the national level. We are already engaging through the good work of Todd Thurlow's community relations officers are engaging with stakeholders at the local level in each of our 24, 25 field offices. But this is a partnership. This is we want to hear ideas about where we should be, who we should be talking to. Certainly it goes beyond AILA members and their clients. It goes into the bar associations, the ethnic bar associations, the ethnic media. So we will do our job to get the message out. I believe that some of our material, not the 13-page memo, will be translated into Spanish, but some other material will be on our website and perhaps other languages as needed. We want to get ideas as to how best to reach out to people so that both unrepresented and represented individuals have full access and opportunity to present their case to us.
Thank you. Aaron? Next question.
Local chief counsel is referenced a number of times in the PD memo. And a question that we had was, is there going to be standard language that is incorporated into the SOPs that local chief counsel is going to be putting out? Will there be proposed forms or checklists for PD requests or to facilitate joint motion requests? And what are some of the anticipated regional disparities that you see coming through through having chief counsel have such a role in this?
Well, I think from a larger perspective, prosecutorial discretion is based upon the judgment and experience of our attorneys, and that's kind of antithetical to forms and checklists and standard operating procedures throughout the country. So we will have local standard operating procedures that, again, we're already setting up meetings with AILA chapters and others to make sure that information is provided. In terms of so it's really a matter of getting the word out. And again, just in terms of checklists and such, we often, I think, unfortunately, because of the large number of in the backlog, we forget that these are families. They're not just files. They're often kids and not cases. So to the extent possible, we want the individual circumstances of each person to be able to be brought out so that we can take the mitigating factors into account, aggravating factors as well to be determined. So it's going to be locally driven, but also driven by the respondent's information.
Okay. Given that it's going to be locally driven to such a large extent, but also, you know, there are the presumed priorities that come out from the national guidance, and so at page 2 of the PD memo, it directs OPLA attorneys to prioritize resources consistent with the presumed priorities. And then it says, and other matters approved under the Johnson Memorandum or by their chief counsel. The question that we have on that is, will local chief counsel be creating their own presumed priority categories? Or is that referring to local chief counsel will approve an individual case as a priority, even though it's not in one of the presumed priorities?
Well, I think you've hit it correctly. we as a shorthand, we talk about priorities, but these are presumed priorities. And part of this is that OPLA doesn't do its work on independently. Our chief counsels don't go rogue, or at least if they do, we have a management system in place to review, and we will have a management system in place to review the types of PD requests that are made, how long it takes to make them, grant rates. We'll have that basic information. But again, there's a balance between the obligations to follow administration's priorities, following national security, border security, public safety, but also to look at the individual cases. So I do not anticipate this is not an opportunity for chief counsel to create their own categories, but certainly the decision making will be at the chief counsel level locally.
Okay, so just to follow up on that, I think some of us were envisioning certain local chief counsel's offices could say, we think that that DUIs are just presumptively so aggravated and so dangerous that anybody with a DUI, even if it's 25 years old, is a priority in our office, and that's a categorical decision, even though it's not necessarily consistent with the presumed priorities. That's not the type of thing that you're envisioning by empowering chief counsel to make these decisions. Is that correct?
Well, looking at the entire 13-page memo as a whole, there are cases to be made for regarding DUIs, and also looking at severity of a crime, how long ago it was when it occurred, rehabilitation factors. So we're trying to get away from strict categories, except for the ones that are clearly enumerated in the law and in the memo from the director and from at the department level. But for the most part, it's going to be individually driven in terms of individual circumstances, case by case.
Thank you. Moving into a little bit about how this is going to look. With the way that the court dockets work, as we all know, there are sometimes hearings set for years out. There have been years-long continuances with COVID issues where, sometimes there's already been some testimony taken in the case on an individual hearing, but it's been continued. First of all, at what point would OPLA want attorneys reaching out to start these engagements, to start these discussions about their cases and the possibility of PD? At the earliest point possible, or are they wanting to get closer to hearings that are set?
I think the answer is both. The earliest point possible in order to get a decision for the non-citizen, to get a decision on that person's request, to economize on attorney resources of all types, and so in that respect, the earlier is good. At the same time, hearings come out all the time. What we want to be able to do, and what we intend to do, is to make sure that if a hearing is coming up quickly, that can be considered on a faster turnaround than a case that has a hearing in 2022 or 2023. We have a limited number of attorneys. People may think we have an unlimited number of attorneys. We don't. We have a shortage. So every case that is going to, every time there's focus on prosecutorial discretion, it takes away from a different case so we want to be able to prioritize the cases where there's a hearing coming up.
And it looks like, from my read of the memo, that individual OPLA attorneys are empowered to make stipulations on particular issues, including, it would seem to me, issues that are central to a case in a application for relief, credibility, hardship, other central issues. Is that the case where the case is properly documented and the OPLA attorney is satisfied that the legal standard has been met?
The legal standard is met with the OPLA attorney in consultation with chief counsel can make that determination. That's certainly something that's amenable to stipulation.
Thank you. Sweet.
Page 5 of the memo references that DHS may elect to not appear in court. I think we saw some of that during COVID, maybe even pre-COVID. So do you anticipate that to be frequent, and how will that be communicated to respondents counsel, and the court in advance?
Well, that has gotten a lot of attention, and I think too much. It's kind of it's what I call the Irish Spring problem. The memo was written for one audience, our attorneys, but we also know that it gets to others. So for our attorneys, it's not really a shocking news that there's under 1240.2b. The chief counsel always has the authority and ability to assign an attorney or not. I don't expect a big change in that going forward. But to the extent that there will be those instances where we feel confident that the rights resolution will occur between the judge and the non-citizen, we may use our authority not to attend. I think, and in any type of action like that, there's a risk of being seen as a lack of respect to the court or to the other side, and we'll do our maximum best to notify and inform whether we're going to be there or not. I would not expect that to occur frequently, but again, this is something in terms of actual how we make that notice. It will be up to our chief counsel. So it's certainly something that they can talk about with you when we have our meetings together.
Thank you. PD requests will be documented in Planet. Will that allow for supervisory review, HQ review? How do we escalate any decisions or matters that we feel need to be escalated?
The PD, the discretion process is intended to be worked out at the local level with the trial attorney making his or her recommendation to the chief counsel. That's the extent of it. Arguments against OPLA not taking it up. It's an additional opportunity for the non-citizen and their representative to make their case to OPLA. They still go into court. We will be reviewing how this works. We intend for it to work. We found before in previous years that when there was a smaller backlog, that doing an affirmative review wasn't all that helpful in terms of providing a relief for individuals. So we will be reviewing it as with anything else. Advocates and AILA and others know how to make their case known when they are not pleased with the situation. Ken Padilla, who you all know as our deputy for the field, is going to oversee this process. And if there are systemic problems with an office, we definitely want to know of that so that we can address it. But as for individual appeals, that's not what we envision with the PD memo.
Okay, thank you. Mitigation evidence. So in the course of this back and forth with OPLA and these open communications, trying to get to PD, if PD is denied, any of those conversations or the content or mitigation evidence presented, will that be used against the respondent in future matters?
I would have to say that'll be a case by case analysis. Typically we wouldn't, but there might be some circumstances where information is there provided. Typically we should we're talking about providing mitigating evidence, which wouldn't necessarily be used against someone. I would have to say that attorneys should be guided by being candid and being able to present and explain. I'm sometimes surprised when people make requests to us and they leave out all of the negative stuff as if we wouldn't know already, or if a police report wouldn't be available to us in certain circumstances. So I'd say there may be parts of information that is provided that is very relevant as to the credibility of an individual, as to some where contradictory perspectives or statements. So I think this is something that you could get a more elaborate and considered answer from our chief counsel. But in general, there is no bar to using that information.
Aaron?
The memo speaks in a couple of places of aggravating factors or serious aggravating factors. And for example, at one point in discussing continuance, it says for people who are non-presumed priorities, in the absence of serious aggravating factors, that should weigh heavily in OPLA attorneys not opposing a motion to continue. What are we talking about here with these aggravating factors or serious aggravating factors for non-priority cases?
I'm not trying to understand what.
I guess
you're
the
talking
question is if you can expand a little bit on how you're envisioning the definition of aggravating factors or serious aggravating factors for those who are non-presumed priority cases.
Well, it could be criminal activity that is recent, that is frequent. It's severity. You have aggravating factors, and the ones that are more severe, more recent, are going to be considered more heavily than others.
There's a little bit of a I don't know if you would call it a mismatch, but just a difference in some of the way some of the sections are laid out. So for example, section 1 lays out who's an enforcement priority. And then section 5 of the memo lays out who would be listed as a good candidate for possibly having the case dismissed. And the question is for people who are not enforcement priorities under those lists, but also not listed as one of the cases that might merit dismissal, what is there for them? With Castro Tomb limiting administrative closure in many jurisdictions, continuances are there and they may be necessary. But is there any thought to making section 5 about dismissals broader to incorporate all non-priority cases? And if that's a possibility, when would such guidance be released?
Well, there's really two answers to that. One is, Aaron, that the priorities, as we said, are presumed priorities. Just because someone's a priority doesn't mean there's going to be prosecution, and just because someone's not a presumed priority doesn't exempt them either. Again, this is going to be case by case. The priorities are not absolute. We will provide more guidance on this when the secretary comes out with further guidance. Right now, we're in the interim stage of the secretary's guidance, the interim stage of the director's guidance, the interim stage of my guidance. As we move more into updated versions of those three, we will provide some more specificity, but that's going to be sometime in the near future.
Okay. Just a quick follow-up on that. When the secretary's guidance comes out, is this memo still durable through that? I mean, or are OPLA attorneys again going to be saying we need to wait for new guidance on the new guidance before we can take decisions in accordance with the secretary's priorities, whatever they may be when they come out?
Well, you're asking me to comment on guidance I haven't seen that's not yet been formulated, but I expect that. So it's my guidance on the guidance. I expect that we will continue this process. We're setting up. It's taken a lot of effort to set this up. There will be adjustments on the guidance in terms of what the priorities are. The priorities may expand, they may contract, they may be viewed a little bit differently. But the basic structure of prosecutorial discretion, where the non-citizen and his or her attorney can request us to review, make a decision on a motion or a joint motion, look at mitigating factors, look at aggravating factors. That is the substance. That is the core, and that I don't see that changing.
Thank you. The next question is about cases that are considered non-priority and also might merit dismissal from OPLA's point of view, but where the respondent wants to proceed with the adjudication of the merits of their case. So, for example, maybe a strong case for a 42B, for asylum, for other relief, or where respondents want EOIR to maintain jurisdiction. So for those cases, will OPLA agree not to move to terminate or dismiss proceedings without respondents' agreement?
Yes, we are not trying to make the non-citizen worse off by exercising prosecutorial discretion. That is why this emphasizes the request from the non-citizen. There will be times when we review a file, we say this might be amenable. This might not be our priority. This might fit under the mitigating factors. We would not do that unilaterally. We would work with the non-citizen, with their attorney, to see whether it makes sense.
Okay, and to the extent that this prosecutorial discretion is aimed at helping to eliminate the backlog in the courts, it seems that one of the impediments to that might be the fact that a lot of respondents want to keep their, again, 42B cases, for example, pending, because that's the way that they qualify for employment authorization. And if they were to accept dismissal, they would not. And so we wanted to ask if there's been any talk between ICE and USCIS of something like a dismissal for PD being the appropriate adjudication / documentation for work authorization under a different category, like deferred action category C14. That would free people up in that situation to actually accept the dismissal, get off the court's docket, and encourage people to seek PD earlier in the process.
Well, as you know, those are matters and decisions that are up to USCIS. If you are interested, or if AILA is interested in approaching both of us or approaching CIS, I'm sure that would be considered. But right now, that's more of a CIS than us to be able to opine on.
Understood. So I'm
Just
going to pass it back to you.
Okay, one insertion regarding that is that I think the members are hearing rumblings about, in order to get PD, that respondents may be required to withdraw applications for relief first. Is that not accurate and not something that's going to come out of the local chief counsel's guidance?
Are you saying come out of it as in it's there now?
Well, I don't know. We haven't seen their guidance, but we're wondering, though, if that is something that will be advised, promoted, or is this the first time you're hearing of this? The requirement that respondent withdraw an application for relief in order to get PD.
I can't envision every circumstance as something we can get back to you on.
Okay. Because that would affect, the scenario we are discussing right now of those who remain eligible for something like work authorization, because of the necessity, if there's this push of requiring an individual to withdraw their application, they would no longer have that available to them. Okay. So moving on, stipulations. This came up during the briefing, the matter of ACAA, which holds that when reviewing a grant of asylum, the board should not accept the party stipulations to or failures to address any of the particular elements of asylum. So this would require respondents, this is commentary now, this requires respondents to submit evidence on and argue each issue, even if ICE stipulates to it, in order to build the record for the BIA. How is OPLA going to address this? How can we converse about this because of this problem?
Well, the problem is getting a stipulation. If we're entering into a stipulation, we want it to stick. There's a mutual and joint interest in having stipulation honored. So if it means laying out the evidence for an IJ finding, then that's what should be done.
So meaning respondents would still need to do that. I'm not sure if I'm expressing it correctly, but respondents would still need to do that out of the necessity to preserve the appeal. Because once it is on appeal, if the judge denies it and respondent does need to appeal that decision, then those stipulations do not stand anymore, irrespective of how great those negotiations and discussions were between OPLA and respondents counsel. And so it is problematic.
Well, so there's a mutual interest in making sure that the stipulations that we agree to are actually honored. And there's a way around it, which is to make sure there's a finding by the immigration judges on those points.
Okay. Okay, so we're going to move forward. I think that maybe that is for deeper discussion, because I did see that during the briefing and now that maybe we need to come to some resolution on that case, because it's very problematic on our end, moving forward with those appeals. But as far as appeals are concerned, the ones that are pending at the BIA and the courts of appeal, how is PD going to be exercised in those instances? Is OPLA going to be looking at those cases to exercise prosecutorial discretion?
I think that the best course of action will be for attorneys to and non-citizens to make the PD request, and those will be considered like others.
Okay. Okay.
Can I follow up on that
Sure.
really quickly? For cases at courts of appeal, is OPLA working with the folks at OIL to implement this guidance, or make sure that cases that are at the courts of appeals can still benefit from prosecutorial discretion?
That is yet to be determined.
Okay. Moving forward, motions to reopen. This is a big topic, and then we're going to move into some questions for ERO. But as far as motions to reopen are concerned, the announcement that came out dated June 9th, we saw it yesterday on Nis Chavez. We've already heard that coming out of some OPLA offices already, they're encouraging motions to reopen filed directly with the court as opposed to joint motions to reopen requests. So meaning bypassing that OPLA engagement and going straight to the court, which of course we have some issues with number and time bars as far as motions practice is concerned. So can you speak to that and respond to that encouragement or advisal that's coming already out of local chief counsel's office to go straight to the immigration court?
Well, as you note, the Nis Chavez guidance came out Thursday or Wednesday or Thursday. Our chiefs now have that. Again, in terms of judicial economy, in terms of if we are working on, in our view, it sometimes is faster for EOR to hear your motion directly rather than having a joint motion. So that's really the genesis of that. But we can talk either at the local level or at the national level on how to address that, how to address any kind of confusion over whether I recognize that the motions are limited. So we want to balance all these factors.
Okay. Well, the guidance stating that OPLA is not going to oppose those motions. If those direct motions are filed, can we assume that we can represent to the court that they're unopposed? Or, I mean, if we can't have joint, can we have unopposed?
You can have
on paper when we write it.
Well, this is important. It's important to be precise. We will work with you to get an understanding on that.
Okay. So more to come. Hopefully we can push for that and get that on paper that we can put it as unopposed. But in many instances, we will still have to rely on the joint motions. It is a strategic decision. We do want to preserve the time and the number bar, well, the number bar specifically, for our clients. As far as the November 16th date is concerned, how is this really in practice? What if a motion is pending with the court, or what if a joint motion request is pending with OPLA and we are on November 17th, November 18th? What happens? Is the November 16th date an adjudication finalization date that you're unopposed, or as long as an activity has occurred, whether a joint motion request, whether a motion to reopen has been filed with the court? Give us some context to that date.
This is in order to address the due diligence requirement on the motions. And it's our statement that we will not oppose if the motions are filed within that time period. We anticipate further guidance overall, because the further priorities should come out this summer. So we put out 180 days. We're a day, like we're very few days into that time period. We will update that as we get closer.
Okay, so by filed, you mean filed with the court? As long as they're
Yes.
filed with the court, not a request filed with OPLA. It is filed with the court.
Right.
Okay. Okay, and then as far as that further guidance is concerned, is there additional guidance to OPLA specifically on this that is more expansive, that has not been shared? Or is that forthcoming?
Well, the secretary's guidance will be updated sometime this summer. We will have a new director, hopefully sometime this summer. If you're referring to the general counsel's memo, that's the general counsel's decision to release or not release. But we get our litigating authority, we get our prosecutorial discretion through the general counsel from the secretary.
Okay, but specific to the Diaz Chavez guidance, is there something more that has been released to OPLA attorneys to help them, facilitate this and assist and everybody move this forward as far as the Diaz Chavez motions to reopen? Is there additional guidance that has not been released?
Guidance with a capital G? No.
Okay. Okay.
There's always discussions between our headquarters and amongst our chief counsels that's on these issues. But I think what I've said here is we provided an announcement on our position on Diaz Chavez. It's on our website. It's for everybody to see. We have upcoming meetings with our chief counsels, with you and your chapters, to be able to talk about PD, to be able to talk about Diaz Chavez. And we've also said that this date of November 16th is 180 days from the decision, and it's a time period to reflect due diligence. There will be more as we get closer to November 16th.
Okay, as far as motions to reopen, additional guidance, not Diaz Chavez, but just motions to reopen, when do you expect that to be released?
I can't tell you because it's partly dependent upon the secretary's guidance.
Okay, and right now, for those general motions or other motions, not Diaz Chavez motions, they're supposed to be evaluated on a case-by-case basis. We've seen situations, a lot of them, where there was a dispositive evolution of law or clear error committed by OPLA and the immigration judge. Are those instances where PD is going to be exercised and in agreement to reopen a case?
You've seen more clear error than I have. I would say that intervening precedent comes into play. Our position on will be guided again case by case basis of people making a request on these motions.
Okay. Thank you, Principal Legal Advisor. We're going to move forward with the questions we have for ERO now. Aaron, do you want to take the lead?
Start. So first starting on detention, I was just pulling up the ICE.gov statistics, and it says that the detained population is now 24,100. And yesterday, Secretary Mayorkas joined us, and he talked about detention. And one of the things that stood out to me is that he was talking about how he recognized that he thought it was overused and that there were other more reliable ways to make sure that people attended their court dates in many cases. And so I wanted to ask what accounts for a rise in detention numbers with new enforcement priorities announced in January, and secretary now who thinks detention might be overused, but we've seen the numbers go up.
Yeah, sure thing. So thanks for that question. Again, I appreciate the time allotted to be here. So the increase, as I'm sure everyone on this line is aware of, we're going through some significant challenges on the southwest border right now. A number of the detainees that are currently in custody, a large majority, are those that have transferred over to us from CBP. Those would be the presumed priority 2 cases, recent border entrants. That constitutes about 81% of the detainee population. So that represents about 19,000 of the detainees that you outlined in the stats that you have on hand. The remaining cases, very much in the minority, are going to be ICE arrests. And of those, about 73% are actually subject to mandatory detention. So, obviously that would be a blend of 236C and 235 cases.
The next question is about the relationship between the priorities and how the ERO and ICE in general sees gang affiliation. And so we've seen what we think are quite sloppy inclusions of gang affiliation that come out of local law enforcement databases. And then once they're in there, it seems like you can never get somebody to look at it again. They're labeled as a gang member, or they're labeled as gang affiliated, and that's it for the rest of their lives. Are there any efforts to decrease reliance on those databases, or to make sure that those findings are actually scrutinized in deciding on enforcement decisions?
Sure thing. So I think in the enforcement priorities, the interim enforcement priorities memo that we're operating under, the gang affiliation and sort of prioritization that's derived from that is very much stratified. I can't remember the legal citation off the top of my head, without the memo in front of me. But that's something that we work in concert with our partners in OPLA to make a determination that appropriately aligns that person with being a legitimate gang member under that statutory definition.
Sweet.
COVID-19 vaccines, what's the plan, distribution in detention facilities, and what are the updates pertaining to that?
Sure thing. So I don't know if I can give too many updates in terms of what we're trying to work on internally. I think that you may be hearing something in the near-term future on that. What I can say is that that is very much on the top of our minds in terms of vaccinating our detainee population at this point in time. We've had about 5,000 individuals vaccinated with the first vaccine, blend of Pfizer, Moderna, or whatever vaccine we have available. I want to say about a little over 1,000 off the top of my head have been vaccinated with the second series. Obviously, I think everybody on the line is aware of how transient the detainee population is in immigration detention, so that's a complicating factor related to that second vaccine administration. We are looking to request more Johnson & Johnson vaccines, just because that is a little bit more conducive to our detainee population, sort of the ebbs and flows of people coming in and out of custody. We are totally reliant for the most part on vaccine allocations from the states. So whatever they have designated for their population, to include inmates in jails and prison in those states, and vaccines that are allotted towards ICE detainees, that we're dependent on them to go ahead and give us those vaccines. So again, it's not the best situation for us to be in terms of reliant on the states, but it's something that we're looking to rectify internally within DHS, and discussions are ongoing.
And as far as gaining release, a refusal to receive the vaccine, does that factor into whether they're eligible for release?
No, it doesn't.
Okay, as far as transfers are concerned, what are some of the updates pertaining to that with the closure of some facilities? What factors are taken into consideration? How do you decide to move people and where to move people?
Right. So I think everybody, is aware of the detainee transfer policy that we have within ERO. That's something that we still operate under. Obviously, we have a number of facilities that have closed within the past several weeks, and we're in talks with a couple of others at this point in time. Things that we look at are sort of the classification, the detainee classification, and whether or not the facility can accommodate those individuals, whether or not the facility has the appropriate mental health care services available to those detainees, and any other factors that sort of are in alignment with that policy.
Do you ever consider location of counsel, or if counsel has already put in a G28?
We do. Obviously, the detainee population, we need to move them around in a way that is operationally conducive for us. Again, I mentioned the challenges on the southwest border. There's a number of locations that we're transferring detainees from the southwest border into the interior to. We've had to move around individuals as a result. It's very dynamic. Obviously, that's not the best type of situation for counsel and the client, but it's something that we are sensitive to. But we are dealing with a very dynamic situation on the southwest border at this point in time.
Okay, so pushing it on the local level, perhaps having those discussions, if we're seeing patterns of our clients being transferred away from counsel.
Right, just speak to the local field office. You have a strong cadre of leadership at each one of those AORs. And if there are some challenges that need to be elevated, feel free. I think you may have my contact information. Let us know if there's any case-specific examples that I need to run down, or anybody else within the organization that needs to look into.
Okay, thank you. We will do that. Transfers have been a problem during COVID, before COVID, have consistently been a problem. So we will do follow up with ICE HQ on that. We do have a lot of focus on that issue. It's very, very problematic for our members as well as the individuals being transferred. Confidential telephone calls. So we do understand that there are a set number of facilities that are offering confidential televideo or Skype calls, but not all of them. And then in addition to that, even when a confidential space is supposed to be provided, we're seeing that during reasonable fear, credible fear, some of those interviews, many of them are not being conducted in a confidential space. So can we speak to that and understand why that's happening, especially when people are making claims for protection, and utmost confidentiality is very important?
Yeah, sure thing. So we have an expectation that those are conducted privately, obviously, given the sensitivity around asylum issues. Again, if there's any case-specific examples, any facilities that need to be specifically addressed, feel free to let me know. Me or my team, we can certainly run that down for you.
Okay, I do have examples. I just experienced it recently, and and there was no navigating out of it.
Mm-hmm.
Okay, so I will elevate that to you.
Thank you.
Aaron, release from custody.
I wanted to start by asking, for individuals from like Haiti, Venezuela, Burma, who are in custody or otherwise slated for removal, being considered for release in light of new TPS designations? And also, is ICE informing these people of apparent eligibility for TPS under the new designations? And then finally, have deportations to these countries continued despite eligibility for TPS?
Sure. So we have actually put out guidance to our field personnel to review all of their dockets to see if there's any individuals that we believe to have eligibility for TPS or deferred enforcement departure, I think for the case of Venezuela, and have instructed them to consider potential release. Obviously, there may be some case-specific circumstances that warrant detention while they go the TPS or DED avenue. We can certainly discuss those on a case-by-case basis, at the local level. But we have put out guidance to sort of look at potential release for those individuals.
We are getting really tight on time, and there's so much we want to get to, but I'm going to pass it to Sui right now to talk about stays of removal.
Yes, so twice we've had some interaction with ICE HQ about the necessity for filing of stays of removal, and we were informed that they would not be necessary unless, by and large, not necessary unless ICE has communicated in some way that it's necessary. The members experiencing the field is really uneven, and for the protection of our clients, obviously best practices would be to file that stay of removal. Can you give us some clarification on ICE's position on stays of removal?
Right, it remains the same. I think I was the one who actually spoke to you about that several months ago. It remains the same. We're not going to require a stay of removal for a non-presumed priority individual. If there are any field offices that need to be addressed specifically, feel free to let me know. We can go ahead and talk to them. But again, it remains the same. Nothing has changed on that.
So non-priority, we're talking about somebody who is a non-priority, but being required to present a travel plan, or because they have a final order, yet not being a priority, and ICE offices engaging with us and stating that, well, we still have to move forward with removal. So, so in those instances, you're stating that a stay is not required?
Right. They just remain a non-priority sort of in perpetuity. And I know that's not the best situation for them to be in. And, there's probably a desire for more durable immigration status or a stay in that type of situation. But we're not requiring stays at this point in time. And, again, if they are requiring travel plans or, enforcing the letter of the order of supervision that individual may be on, feel free to let me know if there's any field offices that specifically have sort of this position, and we can certainly address that with them.
So
Okay.
this is a related question for people who are on orders of supervision. We've had members say that they're having their orders marked no work authorization.
Right.
And the question is, why would ERO be attempting to deny a benefit that's provided by regulation that's supposed to be adjudicated by USCIS by writing that? So I guess that's part one of the question is, and part two is, can ERO put out guidance to the field allowing for more uniform and easy to obtain evidence of compliance with orders of supervision?
Right. So I saw that question, and frankly, I don't know. Again, it's going to be another thing I'm going to have to put on my list to run down for you all. So, please let me know if there's any AORs, any field offices are specifically doing that a little bit more often than others, and we can take a look at that.
Mr. Bernanke, we really can't, I know you have to leave, but we can't have you leave without talking about orders of supervision,
Right.
post-order, custody review. And can you please give us a recitation of how that works right now at ICE HQ, the local level, 90-day, 180-day reviews?
Right. So, it remains largely the same, consistent with 8 CFR 241.
But Mr. Bernanke, it was not applied that way in the prior administration. And we just saw people languishing and languishing and languishing. So are you saying that we are going to actually follow the regulation now?
Well, I believe we actually were following the regulation in the past. I know that there were some issues in terms of the interview process and how that was applied in the field. That's been rectified as of December of 2019. We issued some guidance. There is, I think that's a CFR 241.4E, if I'm not mistaken. That that guidance was promulgated and issued to the field. Closing on 2 years ago at this point. It should be followed. And again, if there's any indicia of that not occurring, please let me know. But again, this is a blend of individuals who are signing off on these decisions at the field level and also at ICHQ.
Okay, thank you so much. ICE unfortunately has another meeting at 2 o'clock. I do want to thank Principal Legal Advisor, Mr. Tresvenia for being here, Mr. Bernacki from ERO, and Mr. Todd Thurlow from the Office of Engagement. But we really do appreciate your time so much. We're going to stay a little bit longer. I hope AILA members will stay, meaning AILA will stay a little bit longer to answer some of the questions and go through them. But thank you so much to ICE. We really look forward to engaging with you further and seeing you at our fall engagement.
Thank you so much. Really appreciate it.
Thank you.
Thank you so much. Really appreciate it.
Mr. Thurlow, are you staying? We would love for you to stay if you can answer questions. We would love for you to stay if you can answer questions.
I wish I could, Sweet, but I've got to go as well. I'm sorry.
Okay, thank you so much. We really appreciate your time. And we will see you in DC. Really appreciate your time. And we will see you in DC.
Look forward to it. Thank you.
Thank you. Okay, so we have a couple hundred people right now still. There's a lot more questions that members wanted to hear. So we're going to go through some of them right now just for perhaps another 5 or 10 minutes. So Aaron, do you want to
All right,
forward
where should we pick up?
why don't we pick up with some of the questions that came through the chat?
Okay. This is a really good question that I wanted to get to, and to everybody still with us, there were some really good questions, and we had way more on our agenda that we didn't get to, and I'm sorry we couldn't, but we'll save these for future engagements. But the question is, how will the PD memo be applied to withholding only proceedings? Will proceedings be terminated, and where would that leave people? And Sui, have you gotten any indication from ICE about that?
I have not. That is a question that we will include on our fall engagement. We are supposed to meet with ICE HQ in person, hopefully in September. So anything that is pending from this chat, as well as on our original agenda that did come up from the 38 chapters and through our national committee. So all of our ICE, EYR local liaison, contribute to this document, seeing all of the examples that came from the members. So we will try to address that question at that time. I haven't received a response on that, but hopefully we will be able to engage with them in writing as well as separately in person in September on that.
I see a question from for ERO that was, will ICE ERO continue to detain applicants at interviews at USCIS? And are USCIS officers still obligated to contact ICE when applicants have removal orders and are interviewed? Obviously, we don't know what they would have said to that, but my expectation is that they would say if they're non-priority people, they're not going to be picked up, even if they have a removal order. I know a lot of us, including me, have had awful experiences with that in the past under the last administration, and so I hope that is done. But lately, I've been able to get ICE to agree in advance that they're not going to do that. So contacting ICE and USCIS in advance to say, hey, this person has an order of removal. We're coming in for an I-130 interview. Can you confirm that you're not going to arrest my client because he's not a priority? And then they'll confirm it, and then we can go in breathing a little bit easier.
Similarly, Andrew Niator had an example of a check-in regarding a stay of removal. So it was just a regular check-in and this dialogue back and forth whether a stay was required. And he was informed that the officer informed him that if a stay was necessary, they would tell him in advance of coming back in with the client. So we're hoping that this type of engagement occurs. You heard Mr. Bernacki now and previously state that the stays would not be required, but that puts us in a very difficult position because we don't know what's going to happen in the field. So, we're still trying to really pin them down on that issue, just because we don't want our clients to be exposed and vulnerable. Regarding the dedicated docket and SmartLink, so some of you know, before we started this call, we asked them how that would work, given the fact that they said that most of the people coming from the border would be on SmartLink, which is an app for all of their check-ins. They clarified that by stating that they would be issuing devices. So I don't know, that seemed really shocking to me, but they would be issuing devices to individuals so they can participate in SmartLink, and the individual can eventually request that that be transferred to a personal device. So the SmartLink device, gives them updates on their check-ins. Apparently, I don't know for certain, but I think that we've heard that it's probably their immigration court hearings as well, but it doesn't have any other capability. You can't text, you can't call, you can't do anything. So it's like, one of those devices for a minor child where it's just one app available. So that was clarified for us because they did state that by and large, almost everybody would be on SmartLink and not with telephone check-ins or in-person check-ins. So that is something that we need to watch, the invasiveness of that monitoring.
Have we heard, and you might know this, is there a process for coming off of SmartLink where once you're enrolled in that?
I don't know that. I think that that's something we have to narrow and push them on, similar to, the removal of any type of monitoring of bracelets, removal of the bracelets, which we've engaged with them in the past. We've asked them for specific de-escalation procedures and how it works, but we all know how it works in the field, which is that depending on who the contractor is, who's, facilitating that program, sometimes they do allow for de-escalation and other times they don't. So we want to know specifically what is it that they want to see in order for us to be able to de-escalate either SmartLink or any type of tether that is required. Any other questions, Aaron?
No, not. I mean, the other ones. I think we really need to get ICE to address them, and so we'll certainly keep these and get them into our next engagement with ICE so that we can continue to get answers to these questions.
We could tell you what we think I should do,
Yeah.
but we can't tell you what ICE could do. But thank you so much for sticking around and staying on this panel. JJ, would you like to make your announcement?
Yes, thank you, Swee and Aaron. And we also want to thank all of the government speakers that were able to join us today. We ask that all attendees complete the evaluation at the end of the session. The session evaluation link is located on the virtual site under each session's description. Your feedback is very valuable for future conference planning. The CLE code for this session is 1324. Again, the code is 1324. Be sure to check out the exhibitors on the exhibit hall page. Thank you to everyone for attending. This concludes the U.S. Immigration and Customs Enforcement, ICE, Open Forum.
Thank you.